If you're getting a divorce, you're going to hear all these terms at some point. So here's a little 101 on what these terms are, what they mean, and why they matter. What is a petition for divorce? Well, a petition in any legal matter, of which divorce is one, is that piece of paper that gets filed in court asking the court to do something. In this case, the petitioner, the person who files the document, is asking the court to, number one, grant a divorce, and oftentimes is also asking the court to do a variety of other things, like if you have children, develop a custody arrangement and a time-sharing plan. If you have assets, which most people do, you'd be asking the court to divide those assets in a way that you would like the court to do, and usually in a way that's considered fair, and a variety of other things as well. But at the end of the day, the court's only going to get involved if you ask them to. And the way someone asks the court to get involved is by filing a petition. What does being served mean? Well, in the context of a divorce, being served means that you've been handed papers by the person who asked the court to enter the divorce. And now that you've been served, meaning handed those papers, you have an obligation to respond. You have to respond within the right period of time, but also you need to respond in the right way. And if you don't do that, unfortunately, something called a default can be entered against you. And essentially what that means is all of the things that the other party asked for are going to be granted. So when you've been served, when you've been handed that lawsuit, when you've been handed that petition, make sure you read it carefully, make sure you respond in time, and make sure you respond the right way. A lot of people will ask, what's the difference between a petitioner and the opposing party, and how do I know which one I am? Well, it is actually kind of easy. The petitioner is the person who files the petition, or that first paper asking the court to do something. If you didn't do that, you're not the petitioner. The opposing party, sometimes called the respondent, is the person who has served the petition by their spouse. And that's a document that's asking the court to essentially enter a divorce. So if you didn't go to court and you didn't file papers asking to get divorced from your spouse, odds are you're the opposing party. And if you're the one who initiated the action, if you're the one who filed that paper first, you're going to be the petitioner. Okay, so usually the last part of a divorce case is the judgment. But what is the judgment? And what is it in the context of divorce? So a judgment in a divorce case is going to be the final ruling from the judge on all the issues that have been put before the court. The main component of a judgment is going to be the dissolution of the marriage, a judgment that says you are no longer legally married to your spouse. It can have things like reverting to your maiden name. It can have things such as defining what the date of the divorce is. And that can all be very important when it comes to things like benefits or assets and who they belong to. But there's going to be other things involved in a judgment as well, in addition to just legally dissolving the status of the marriage. In a judgment, typically there's going to be things like division of assets. Who gets what? Who's going to be responsible for which debts? Who's going to get the house? Who's going to be responsible for the car? And also, if you have children, who's going to be in charge of those children, if you will? Who's going to have custody? How will the timeshare arrangement work? All of those things which a judge ultimately orders in the case are set forth in a judgment. And that's a written document that's filed with the court, and it's legally enforceable in every state.